Hello and welcome to some more StarCitizen news with an update and recap of the CIG versus Crytek lawsuit. The court has ordered that a bond of $500,000 be put up by Crytek to protect CIG in the event that they are the prevailing party. This is actually a lot less than CIG wanted for the bond. The original bond requested was for $2.2 million. So why did the court award the bond, but for much less than CIG requested? And what are the court's thoughts on the case so far? The bond is to protect CIG from having to be fully liable for their lawyers' fees if they're the prevailing party and Crytek didn't have enough money to be able to pay their fees. It was made available to CIG as Crytek are a foreign entity and have a history of financial troubles, but these troubles and the way CIG argued them may have been overly convincing to the court. Let's take a look at the court document that did a bit of a recap and sort of like went through what the court thought about the case so far and as they understand it. And please remember, I'm not a lawyer and this is my understanding of the situation and my opinion, and the court documents are all linked below if you'd like to follow along at home. Crytek, the plaintiff, claims that the defendants, CIG, conduct violated their GLA, the game license agreement, and asserts claims for breach of contract and copyright infringement against them. Previously, the court dismissed two separate theories that the GLA prohibited CIG from using any game engine other than Crytek. Basically, the court went, they can use Lumberyard if they want to, they can change engine. Crytek's complaint now only asserts claims for breach and copyright infringement stemming from 1. Crytek's use of CryEngine in its game Squadron 42, 2. CIG's failure to timely deliver bug fixes and optimizations to Crytek, which they were supposed to do, and 3. CIG's decision to remove copyright and trademark notices crediting Crytek in association with CIG's StarCitizen game, and 4. the alleged disclosure of CryEngine source code in online videos that CIG publicly released. This is bug smashes, and apparently they showed some code on screen potentially. In the court's opinion, CIG showed that there was a reasonable possibility that they would prevail, which the court required to award the bond, though this hurdle is apparently a relatively low one. The court said, while Crytek, a company based in Germany, unquestioningly qualifies as a foreign corporation, the parties dispute whether defendants can show a reasonable possibility of prevailing on the merits of the plaintiff's remaining claims, and whether defendants have requested too large a bond. The court concludes that defendants have a reasonable possibility of prevailing, but the plaintiff need only post a fraction of the bond defendants seek. So the prevailing party may seek relief of their expenses from the other. The prevailing party is the one that recovered the greater relief. However, there's going to be lots of discussions about that in the future, I'm sure. The court must therefore take into account the fact that the court has already dismissed 2 of Crytek's key breaches of contract and theories. CIG have also demonstrated a reasonable possibility that they will prevail on Crytek's remaining claims. So CIG argue that they are likely to defeat Crytek's claim that the game license agreement prohibited CIG from using CryEngine to develop Squadron 42, given that the GLA explicitly grants defendants the right to exclusively embed CryEngine into the game and develop the game, and defines the game as Space Citizen, oddly not Star Citizen, but Space Citizen, and Squadron 42 together. Defendant's success on this claim is at least reasonably possible. Defendant, CIG, next contend that they took an action that satisfied their contractual obligation to deliver certain bug fixes to Crytek annually. Crytek make alternative arguments that CIG's actions didn't qualify as an annual delivery, and that CIG eventually delivered the bug fixes after the lawsuit began, a development which would amount to a win on the side of Crytek's sort of board. Answering whether, as a factual matter, CIG met its obligation to deliver bug fixes annually will require the court to answer factual questions inappropriate for resolution at this time. It also requires the court to decide whether the GLA's language renders moot the parties jostling over whether and when CIG would deliver the fixes. The fact that either result appears reasonably possible at this stage means that that moves in favour of requiring a bond. Even if the court eventually decides that CIG's delivery of bug fixes after the litigation began qualifies as a positive result for Crytek, the court would likely look at the result in the context of litigation as a whole. In light of the court's dismissal of previous claims and the reasonable possibility of success of the claims, Crytek's potential victory on the issue is not enough to compel the conclusion that defendants, CIG, stand no reasonable chance of prevailing in the end. Crytek also claims that CIG breached the GLA by removing StarCitizen copyright and trademark notices that indicate CIG used CryEngine to develop the game originally. CIG respond that they no longer need to use such notices because they switched from Crytek's game engine to Amazon Lumberyard's game engine. Crytek does not dispute that the switch occurred, but contends that CIG should have credited Crytek nonetheless, because Amazon-based Lumberyard largely uses CryEngine source code after Crytek sold the code to Amazon. The effect of the similarities in CryEngine and Lumberyard source code is a merits issue that the court need not resolve now. It's enough for the court to decide that the evidence before it indicates CIG switched the copyright and trademark notices only after it began using Lumberyard instead of CryEngine. CIG therefore stand a reasonable possibility of success on that claim. Finally, in response to Crytek's claims relating to the alleged unauthorized disclosure of Crytek's code, CIG say that disclosure in the Bug Smashers video caused no damage to Crytek because Crytek had already made a substantial amount of its code publicly available. Indeed, the record shows that Crytek made CryEngine publicly available on a pay-what-you-want basis, allowing users to access the platform without necessarily paying anything. Crytek does not dispute that evidence, since proving breach of contract requires Crytek to show that the purported breach actually caused damages. The fact that its source code was publicly available before CIG released its Bug Smashers videos is enough for the court to conclude that defendants have at least a reasonable possibility of success on that claim, since CIG have already succeeded on 2 claims and have a reasonable possibility, if not a greater possibility, of succeeding on others. As discussed above, this factor weighs heavily in favour of requiring a security, the bond. So from that, we can see the court sees that there is need for a bond for CIG's financial security, and they believe that there is at least a reasonable chance that CIG will prevail, as it already has done on some matters. However, the court went on to say that they wish to reduce the amount of the bond as to not bar Crytek's access to potential legal remedies. They don't want to gate the sort of like legal system to people that can't afford it. And this might have been partly down to how CIG argues that Crytek is in severe financial distress. They cite media reports that Crytek has for some years been teetering on the brink of insolvency. They also point to Crytek's downsizing and failure to make payroll. Further, Crytek's experienced a 62.3% revenue drop in 2015. Revenue increased slightly in 2016, but Crytek had to take out and modify significant loans to remain solvent. More reports surfaced that Crytek wasn't able to make payroll and had to close several production studios that year. CIG claim that Crytek has not filed financial reports for 2017 and 2018, and that Crytek does not dispute that fact. Indeed, Crytek does not dispute any of CIG's evidence indicating that Crytek is in financial trouble. While this evidence may bolster the justification for a bond, it also shows that a $2.2 million bond that CIG request may not be reasonable when viewed from Crytek's perspective. The court must be careful to not deprive a plaintiff of access to federal courts by forcing them to post an excessive bond. If Crytek is in as much distress as CIG believe it, then requiring it to post a lump sum of over $2 million could push the company closer to financial ruin or effectively bar it from further participating in the suit. Basically, CIG arguing that Crytek were in dire straits financially helped them get a bond, but the court won't make them put up a $2.2 million bond because they don't want to stop Crytek from being able to continue litigation. An extremely fair judgment from the court, if you ask me, and a sensible one. CIG claims that they've already spent over $380,000 in attorney's fees on this matter so far, and provide an estimate that they may incur another 1.6 million-ish over the course of the litigation. Crytek disputes the reasonableness of both amounts, but does not provide the court with a figure that it could reasonably post as security. It requests that only the required bond be substantially decreased if the court finds a bond warranted. Given the absence of such context, the court shall require require Crytek to post a bond in the amount of $500,000. Such an amount will protect the significant amount of fees that defendants have already incurred, but will likely not jeopardize plaintiff's ability to continue its participation in the action. So this bond might be very useful for CIG for both financial protection, but also leverage in any settlements. It doesn't affect the possibility that CIG may not be the prevailing party, or that CIG may incur more costs and request them back. They can have higher fees and they can claim those back and still get them. It just gives them extra security if for some reason Crytek can't pay. CIG and Crytek, as I understand, have been in settlement talks, and I expect these will continue and potentially be resolved before the discovery phase goes into full swing. This is where the parties sort of request emails, documents, and lots of information from each other, which can be burdensome and costly. There is also a risk, settlement-wise, that CIG would be unwilling to settle once they've started to spend money on discovery, as they might as well fight it and try and get all their money back. But that's just my opinion. That's certainly not legal advice. Crytek's case is looking pretty weak in my opinion, but something could come up in discovery. I personally don't like the fact that Crytek is suing CIG and StarCitizen, but it's possible they've been genuinely wronged in some regard, although their creative use of rewording things to say, well, they weren't allowed to change engine, they weren't allowed to do this, it was obviously proven wrong, and it was, in my opinion, a wrong thing to sort of like fight on. But I certainly don't begrudge Crytek's employees for the decision of higher-ups and lawyers either. It's just a bit of a shitty situation, which I do hope gets resolved soon, though if a settlement is reached, we are unlikely to know anything more than a settlement has been reached. But we'll cover the story and continue to cover it as we know more. If you have any questions about the lawsuit or want to share your opinions, then please chuck them in the comments below. But please be civil. I'm fine for people to talk and discuss this sort of stuff and to share ideas or their disdain or anger or whatever. As long as you're doing it in a relatively civil way, then I'm pretty good with that. Just remember, some people have different opinions from you, and you know, don't be angry. Don't be too angry. There's no need to be. Every month we have a ship giveaway. For July, it's for an 890 Jump, the mighty luxury ship. To be in for a chance of winning that, just be subscribed to my channel and comment on any of my videos this month. More details down below. This has been donated by My Radar. They make a real-world weather app, and this also has some of the astral bodies from StarCitizen in there too, giving some really interesting information. It's getting more updates and functionality, that app as well, and they're adding the planets into the game too. I'm also shilling for NordVPN. If you're looking for a VPN, check them out, as they offer many benefits over free services and allow you to more securely and more freely access the internet, as well as helping you be protected while you're playing online. If you're looking for a gaming PC or upgrade instead, consider Shadow as well, a cloud gaming service that allows you to stream a Windows 10 gaming PC environment from a data center directly to your phone, laptop, PC, or other device. It's great for StarCitizen as long as you have an appropriate internet connection. For both of those services, NordVPN or Shadow, please use the code BoredGamer for discount. If you would like to further support my channel and for more StarCitizen content, consider becoming a Patreon or YouTube member with that join button below my videos. All the links and all that sort of stuff down below. If you've got any feedback, if you'd like to talk about anything that we've talked today, if you've got any questions, whatever, I'd love to hear from you in the comments below as well. Thanks for watching, guys, and I'll see you in the verse.